Hello everyone. Welcome back to our channel, Immigration Canada. Canada's new citizenship rules effective December 15th, 2025. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. As of December 15th, 2025, Bill C-3, an act to amend Canada's Citizenship Act, is officially in effect, marking one of the most consequential citizenship reforms in decades. Designed to correct long-standing inequities in how Canadian citizenship is passed down through generations, this legislation finally closes painful legal gaps that left thousands of families excluded. For Canadians living abroad, descendants of lost Canadians, and families with international roots, Bill C-3 represents more than a policy update. It is a long-overdue restoration of belonging. The law recognizes that Canadian identity does not disappear at the border and that modern families maintain deep connections to Canada, regardless of geography. Ending the first-generation limit, who benefits now. Introduced on June 5, 2025, and granted royal assent on November 20, 2025, Bill C-3 removes the controversial first-generation limit on citizenship by descent, both retroactively and going forward. This change means that individuals previously denied citizenship solely because their Canadian parent was also born abroad are no longer excluded by default. The reform applies automatically to eligible individuals born or adopted before December 15, 2025, offering immediate relief. Retroactive citizenship for lost Canadians. Under the new law, citizenship is automatically granted to individuals affected by outdated provisions, including descendants of lost Canadians missed by earlier reforms, children born abroad to Canadian parents who were themselves born or adopted outside Canada, adopted individuals facing similar exclusions. Eligible individuals may now apply for proof of citizenship through IRCC, without fear of rejection based on generational technicalities. Importantly, those who already applied under interim measures introduced after the 2023 court ruling do not need to reapply. Their cases will be reassessed under the new law. A modern safeguard, the substantial connection requirement. For children born or adopted abroad on or after December 15, 2025, Bill C-3 introduces a new safeguard designed to preserve the integrity of citizenship while remaining fair and inclusive. If the Canadian parent was also born or adopted outside Canada, they must demonstrate a substantial connection to the country. This is defined as 1,095 cumulative days, 3 years, of physical presence in Canada before the child's birth or adoption. This requirement reflects balance, not restriction. Time spent in Canada as a student, worker, or resident all counts. The rule applies equally to biological and adopted children, reinforcing fairness across family structures. How to navigate the new citizenship rules. If you believe Bill C-3 affects you or your family, a clear path forward is now available. Confirm eligibility. Visit IRCC's citizenship section to assess whether you qualify retroactively or under the substantial connection rule. Apply for proof of citizenship. Submit Form CIT-0001E, along with birth records, adoption documents, and proof of lineage. Processing is being prioritized for affected cases. Prepare substantial connection evidence. Collect documents such as tax filings, school records, employment letters, or utility bills showing physical presence totaling 1,095 days. Renunciation, if desired. For those granted citizenship automatically but wishing to decline it, a simplified renunciation process is now available. IRCC has expanded resources, including helplines and informational webinars, to manage the anticipated surge in applications. Why Bill C-3 was necessary, a history of gaps. Canada's citizenship framework dates back to 1947, when early laws unintentionally stripped or denied citizenship to certain groups. Amendments in 2009 and 2015 restored status to many lost Canadians, yet critical gaps remained, especially for descendants and families affected by the first-generation limit. These exclusions caused real harm: families separated, children denied passports, and individuals locked out of their heritage. The system failed to reflect how Canadians actually live and move in a globalized world. The court decision that forced change. Everything shifted on December 19, 2023, when the Ontario Superior Court of Justice ruled that the first-generation limit violated equality rights under the Canadian Charter of Rights and Freedoms. The federal government chose not to appeal, acknowledging the injustice and committing to reform. That decision laid the groundwork for Bill C-3 and for a more humane, constitutionally sound citizenship framework. The bigger picture, what this means for Canada. Bill C-3 aligns Canadian law with modern realities. It strengthens ties with a global Canadian diaspora, encourages reconnection, and positions Canada as a leader in balanced, values-driven citizenship policy. More than legislation, Bill C-3 is a statement. Canadian citizenship is not a technical privilege, it is a living bond. By repairing historical wrongs and charting a fair path forward, Canada has reaffirmed who belongs and why. Bill C-3. Frequently asked questions. What is Bill C-3 and when did it take effect? It amends the Citizenship Act, removes the first-generation limit, and took effect on December 15, 2025. Who qualifies as a lost Canadian now? Those who lost or never gained citizenship due to outdated laws, including descendants previously excluded. What is the substantial connection rule? Parents born abroad must show 1,095 days of physical presence in Canada to pass citizenship to children born abroad after December 15, 2025. Do you need to reapply if you applied earlier? No. IRCC will reassess existing applications under the new rules. How do you apply for proof of citizenship? Through IRCC using Form CIT-0001E with supporting documents. That is all for today, in this video. See you later, in the next video. Till then, take care.